Hey everyone, welcoming you all. So in today's video, we're going to understand the very origin of statute, what is the meaning of statutes, what are the definition given by many philosophers of statute. Then we will understand what is the definition of statute law along with just important stuff. So let us first know about the origin of statute. Origin of statute is from old French status from the late Latin statum means law. Regulation from Latin statute means setup. Station and from status means position, state. So here you can see the statute is from old French, that is status, from where the word statute comes from, and from the late Latin statum. So old from old we got status, and from late Latin we got statum means law, regulation. So these are the meaning of statute. From Latin statutory means set up, station, and from status means positions, stated. So these are the terms given by French and Latin. It is said that statutum was first used on an Act of 55 of Henry III. So the first time it was used on Act of 55 of Henry III. The term statute come into existence in Middle English as statute during 1250 to 1300. So this is the time period from where the very word or the term came into existence. The synonyms of the term statute are law, rule, act, ordinance, enactment, regulation, decree, and edict. So if we say any of this, that will mean that we're talking about statute only. So let's move into the meaning of statutes. The meaning of the term statutes varies according to connotation in which it is used. The following are the given meanings of the term statute. So these are some of the meanings that has been given very crisp point. I'll try to read it, then I'll try to explain it. In archaic, in biblical use, a law or decree made by a sovereign or by God. A decree or edict as of a ruler, a law enacted by a legislature that is also known as statute, an established law or rule as of a corporation that is also in statute. In modern state, statute is being used with the following meaning. So if we talk about statute, in earlier period, it was known to be something that is sovereign or by God or by a ruler. Then after in modern period, the meaning of statute has been no has many differences in meaning. So now we will understand in modern sense as well. In modern sense, statute is being used in the following meanings: enactment or legislative body expressed in a formal document. So if it in a formal document, then we'll only consider it as a statute. If it's not mentioned in a formal document, we will not call it as a statute. Permanent rule made by a body or institution by the for the government of its internal affairs. So the rule that will be made should be permanent. A written law passed by a legislative body, violation of the hate crime statute. So it has to be written. An unwritten law will not be considered as statute. A formal enactment by a legislature, it has to be in a formal manner. An act passed by a legislative body. So if any legislative body also pass some act, that will also known or considered to be as statute. A legal document codifying the result of deliberation of a committee or society or legislative body. So this is also a definition or meaning of state. A legal document codifying the result of deliberation of a committee or society. So these are some of the meaning of statutes from ancient era into the modern era itself. Now we'll move into the definition of the term statute. So when we talk about meaning, meaning generally talks about the kind of meaning that normally used in digital life. But when we talk about the definition, that means there will be some philosopher or some very important figure who has defined a very term. So as per Black's Law Dictionary, statute is a particular law enacted and established by the will of the legislative department of government expressed with the requisite formality. So this is one as per the Black's Law Dictionary. So whenever we try to write something relating to statute, if we can add some of the definition given by some of the very prominent figure, our answer will be more improved in nature. So we should always try to add some of that necessary information. According to this Tomlin's Law Dictionary, statute signifies an act of the legislature. Maxwell defines statute as the will of the legislature. So the will of the legislature is also known as the statute, which will be very easy to remember for any student. So you can, if it's the other definitions are being a bit lengthy, you can also refer for what Maxwell says about statute. According to Back, every statute is the formal expression in writing of the will of the legislature in a state. So it has a similar meaning that has given by Maxwell. Halbert's laws of England state The statute is a declaration of the law as it exists or as it shall be from the time at which a statute is to take effect. So, Halisbury Laws of England stated a statute is a declaration of law. Sutherland says a statute is merely a structural device through which the determined principles set forth by the legislature is preserved from the regulation of private conduct and for the limitation of the governmental activity. Some definition has been given by various persons. Some say it's an declaration, some say it should be in formal writing, some say it is the will of the legislature. So these are some of the definition given by the this particular person that I have mentioned here. So now we will understand what is common law. So common law is a legal system developed in England after 1066 when William of Normandy became king. So it was back in England in the year of 1066. It was created to make the law uniform across the whole country. The very aim of establishing common law is to bring uniformity across the whole country. It is called common because it applied to everyone in England, not just local areas. So it is very much common in England and it was applicable to all. It was based on customs, court decisions, and the rulings of the royal judges. So these are the necessities that was under the common law. Judges traveled around the country, called general ire to hear cases and share legal practices. So judges were traveling around the country in order to understand the cases and to share legal practices. Over time, they kept good customs and rejected bad ones, forming a single system of law. So, based on the cases they have heard, so whatever they found valuable and beneficial, they started to add into the common law, and where rejected the one they feel that is not suitable for the society. The idea of stare decision following previous decision made the law more stable and predictable. So, this is the maxim. So, based on the previous decision made the law more stable and predictable. Common law is still the basis of legal system in many countries like the UK, USA, and India. So we still have the concept of common law, including UK, USA, and India. So let us know about what is statute law. Statute law is frequently used interchangeably with statute, but the term is broader in its meaning and includes not only statutes that are already defined, but also the judicial interpretation and application of that statute. So now we have statute law, which is more broader in sense, and it includes judicial interpretation as well as very act and application of such statutes. So now let us know statute law to prevail over common law. Statute law prevails over common law in democracies. Lawmaking powers are vested chiefly in elected officials in the legislative branch. The vesting of the chief lawmaking power in elected lawmakers is the formulation of representative democracy. Aside from the federal and state constitution, statutes passed by elected lawmakers are the first law to consult in finding the law that applies to a case. So usually back then we used to have common law, then we got to know statute law which prevails over common law. So now let us know about the evolution of lawmaking processes in England and modern democratic system. So earlier in ancient era in England itself we used to have this common laws, and now with the evolution we will understand the uh, statute law in today's sense. While common law in England initially evolved from judicial decision custom, modern law making law follows a structured legislative process. So this is the very differences between common law and statute law. In contemporary parliamentary system like India, influenced by the British model, laws are created through bills introduced in the legislature. So nowadays we have this proceeding that if and in order to make an act, there should be a bill passed, and with the proceedings it will become an act. The first step in this process is the first reading, where a bill is formally introduced in either House or Parliament. This marks the shift from judgment law to statutory law, showing how legal systems have progressed from unwritten customs to codified. So this is how law has changed with the time period. Earlier we used to have another kind of pattern. Now with the pattern has been changed, so there should be a first reading, then second reading, a bill will be introduced, then it will become an act, so like that. So it is not a judgment law, it has changed over time. Now let us know about the second reading motions after introduction. So as I said in the previous slide that it has to be introduced in the parliament in the first reading itself. Following the first reading, where a bill is formally introduced without discussion, the second reading represents a critical stage of legislative scrutiny. Unlike the common law tradition, where laws evolve gradually through judicial reasoning and customs, modern legislative procedures, like those in India's parliament, allow for structured debate, expert review, and public consultation. So earlier the process was much different. Now we have another process. So After the first reading, the second reading is more crucial. In the second reading itself, all the details will be scrutinized thoroughly, and after that only the decision will be given. This shift reflects the development from judgment law to transparent participatory lawmaking. So this has been done in order to make it more transparent and more participatory lawmaking, where bills can be referred to committees, amended and debated clause by clause to ensure comprehensive evolution before becoming. So as I say, second reading is the crucial one where it has been, scrutinized in a more broader sense. So now comes the third reading, passing of the bill in the House where it was introduced. So the bill was introduced, it was scrutinized. So now comes the third reading. When a motion that the bill taken into consideration had been carried out and no amendment of the bill has been made, or after the amendment are over, the member in charge may move that the bill be passed. After the motion that a bill may be passed is carried, the bill is taken as passed so far as the House is concerned. This is how a bill becomes an act after the first reading, second reading, or third reading, and how the common law has been changed with the passing time, become and it becomes a statute law. So this is all about the meaning, origin, how was the common law system was, and how come we have the statutory law, how the bill has been passed. All the necessary information I have tried to invest in this video itself. So if you find this video valuable, do like, share, and subscribe. We'll be meeting soon with another such content.